exception of the appellant/applicants. Consequently, and inevitably, each of us, of this bench, does hereby recuse him or herself from further participation in the hearing and determination of the appeal dated 25th April 2023 and filed on 26th April 2023. My Lord, that's a decision that was made just when these petitions were ongoing. So, when allegations of bias and working towards a certain outcome are made, what the Supreme Court recently is it recused itself. My Lord, I have a decision, an Indian decision. It's called State of Punjab versus Davida Pal Singh, which also the question of recusal was discussed at length. And again, I do not want to dwell on the whole decision. Is a very lengthy one. It's about 400 pages. But at page 9, at paragraph 16, the court set the standard that is applied in determining whether a bench should recuse itself. And the test, I read, the test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely, and whether the adjudicator was likely to be disposed to decide the matter only in a particular way. The court went on to say, the court has to proceed observing the minimal requirements of natural justice, i.e., the judge has to act fairly and without bias and in good faith. A judgment which is the result of bias or want of impartiality is a nullity, and the trial coram non judice. Therefore, the consequential order, if any, is liable to be quashed. Lastly, and this is what is very important, at paragraph 18, the court said in part, however, if there is real ground for doubt, that doubt must be resolved in favor of recusal. So that, my lords and my lady, if you are in doubt whether you should recuse yourself or you should not recuse yourself, that doubt should weigh towards recusal. That decision will be shared. And then the court went on to quash some proceedings which had taken place, an appeal had been determined, and then this one went all the way to the Supreme Court of India. So the court said that that is how situations of bias are treated. I had reference to the code of conduct of judicial officers. I think that's what Mr. Gachagua was referring to. My Lord, I want to lay the basis as to where those provisions are obtained from. And those provisions are obtained from the IPA guidelines on conflict of interest in international arbitration. You will find that material is published by the I located it from the International Bar Association, and it was done first in the year 2004, and it has been applied worldwide as a guide on determining situations of conflict of interest. And it has graded conflicts in several shades, the traffic light shades. There's green, there's brown, and there's the waivable, non-waivable, waivable, green, and the brown. And at clause 2.37, one of the situations that is a waivable conflict is the arbitrator has a close family relationship with one of the parties or with a manager director, or member of the supervisory board, or any person having a controlling influence in one of the parties, or an affiliate of one of the parties, or with counsel representing a party.